Justice has a way of catching up to those who think they're above the law, and when corrupt cops face the ultimate reckoning, the courtroom turns into the stage for instant, dramatic consequences. Like this first cop, who got humbled by a prosecutor who showed him absolutely no mercy.
Get your hands up! Get your hands up! That's what he's treating. That's how he's treating a stranded citizen.
Sometimes the courtroom becomes the ultimate stage for justice, where no badge can shield the truth. Today, we're diving into those unforgettable moments when corrupt cops were exposed and owned in front of a judge.
I have no idea what's going to happen right now. I do know one thing. There's going to be one side who's going to be brokenhearted. One side's going to be brokenhearted. We know that for sure. What I ask everybody, and then I follow it up with I'm ordering, that I am respectful that this is the most pressure-packed moment for most people in their entire lives.
On March 7th, 2019, following a decision he made that resulted in the most horrifying circumstance conceivable, Palm Beach officer Newman Raja was informed of the verdict of his trial, and the result was far from pretty.
I hereby sentence Mr. Raja to 25 years in the Department of Corrections. That is as a minimum mandatory, which was required that he serve day for day.
However, 8 days before, at the start of Raja's trial, the prosecution had disclosed the true reason for his detention.
That defendant right there chose to refuse to act like any reasonable law enforcement officer approaching a stranded citizen in help. That is why Corey Jones died that evening. He recklessly created a situation which could only be expected to result in somebody being seriously injured or killed. You see, this isn't just a tragic story. This is a tragedy that was created. It was created by him. It resulted in an innocent man being killed. Corey Jones was doing nothing except waiting for help on the side of the road because his SUV broke down. And one of the few people that should have unquestionably been there to assist him on the side of that road did exactly the opposite. Instead of being Corey Jones' saving grace, he was his angel of death.
In this instance, Corey Jones was the victim, and his contact with Raja was his final moment.
The evidence will show that there's no way Corey Jones knew, even at the time that he was running, fleeing from the back of his vehicle, running into the dark, seeking cover, laying there on the ground, dying, breathing his last breath. No way that he knew that the person that actually shot and killed him was a law enforcement officer. He's out at the middle of the night on the side of the road, stranded. And unlike a lot of folks in this world, he was patient, he was nice. All he wanted was some help to get home. You'll hear it with your own ears. You'll hear how he's calm. You'll hear how he's giving her information just to get the help that he needs. But see, unfortunately for Corey Jones, his bad luck was turning much worse. Because unknown to him, that defendant was on duty.
Officer Raja responded as Jones waited for non-emergency assistance, and Jones unfortunately paid the price for circumstances which were out of his hands.
See, he was a police officer at that time in Palm Beach Police Department. He was working a detail, a plainclothes detail, where he was supposed to surveil neighborhoods, looking for car burglars. And if he saw anything, he's supposed to call up marked units to come and take care of the issue. And he has supposed to be wearing a tactical vest, like you see on TV, in the news, maybe even in person, with big letters that say police across it, so everybody knows who he is. If he gets out of that van, an unmarked van, he's supposed to be clearly identifiable as a law enforcement officer.
Raja chose to play the judge, jury, and executioner roles rather than taking any of these measures.
And instead of doing what everybody would expect a law enforcement officer to do when they're approaching a stranded, a potentially abandoned, but at least a vehicle that's stranded on the side of the road. That defendant did everything wrong. He did everything that you would not expect. He's driving an unmarked white van, and he comes along and he goes up the wrong way of an I-95 exit ramp.
Raja also asserted throughout his trial that he had introduced himself to Jones as an officer, although an audio recording refuted this. This was the starting point of his downfall.
Now, Corey Jones, he's got an expensive job. He goes into not the nicest parts of Delaware Beach for his job. So he did what any lawful American can do. He purchased a firearm, .380 handgun. You can't even try to create the situation he got that gun 2 days prior to this event. It was still in the box in his glove compartment. But as soon as that defendant recklessly pulls up to him at 3 o'clock in the morning, in the way that he did,
this would refute Raja's other assertion, namely that Jones's armed status was the reason his hand was forced.
Corey Jones knew what was exactly about to happen. What any reasonable person could expect to happen. You'll show through the evidence today and through the next 2 weeks what Corey Jones was thinking. You'll hear how Corey Jones had that gun in that box. You'll hear the chimes of the door opening on Corey Jones' SUV because he still had the keys in the ignition. And you'll hear the last words that Corey Jones ever spoke in this world. They weren't confrontational words. They weren't fighting words. They were calm words that unfortunately turned to fear. Because there's the defendant. Nothing that shows he's an officer. He didn't even pull out the badge, which was in his wallet, in his back pocket, to show to Corey Jones. Much less put on that vest that said police, or even had his radio or his gun. There's no verbal identification that you're going to hear on that recording when Corey Jones was talking to that sales representative that had to sit there and witness this horrific event unfold.
Given how seriously Raja's conduct was portrayed, the prosecutor's response was entirely justified by the facts of the case.
Yeah, I'm good. Really? That's what he's saying. That's not how an officer talks to a citizen at 3 o'clock in the morning on the side of the road. But that's how he spoke to what he saw with Corey Jones on the side of that road. All the while, when he's saying this, when you listen to this tape, realize things didn't stop. We're not all of a sudden just done with action. As this defendant is saying these words to Corey Jones, and Corey Jones is responding back, he's getting closer and closer to Corey Jones. He's actually chasing Corey Jones away from his vehicle. Corey's already retreating back out of his doorway to the back of his vehicle. A citizen that's stranded on the side of the road, already being chased from his vehicle.
Given what transpired, it is horrifying to believe that Raja didn't pause for even a moment before profiling Jones.
Get your hands up! Get your hands up! That's what he's screaming. That's how he's treating a stranded citizen. Immediately within seconds, that's what he's saying. Profane orders being shouted at a time when a guy is sitting with a broken down car, trying to get home. And what is Corey saying? He doesn't respond in kind with profanity. He says, hold on, hold on. Once again, get your effing hands up. Drop. 3 shots.
Apart from Raja's intention to kill a man in cold blood, something the jury was definitely not allowing him to get away with, none of this was justified.
He didn't ask for it. It got thrust upon him by the person that was supposed to be caring for his safety. He made a decision to shoot first and ask questions later.
Raja is a symbol of everything that is wrong with the police force today, which permits complete psychopaths to hold high positions.
He's thrown down the gun already that he had in his hand that was meant to protect him, and you consider that Corey Jones is running for his life after being shot at on the side of the road. That's forever. 10 seconds between the third and the fourth shot. 10 seconds for a young man running for the color of darkness. 10 seconds for that defendant right there finally do what he is supposed to do as a law enforcement officer. But that's not what the evidence is going to show he did. It's going to show his recklessness. His absolute reckless behavior from the start is now changing. It's evolving. It's now becoming a premeditated intent to kill.
The facts would go to show that this was something far worse than an accident or a case of ineptitude.
He waits over 30 seconds. 30 seconds to call 911. And why was he calling 911? Because he didn't have his radio on him like he's supposed to. He had to use his own phone to call 911, and he waited 30 seconds to call. Before getting medical assistance for Corey Jones, before getting much needed assistance, if he was truly in fear of his life, when he needs to call a coward, 30 seconds. Doing what? Letting Corey Jones die. And how is he going to act?
This could be the lone instance in which the prosecution was incorrect. It's very possible that Raja has done this before. He doesn't seem like a first-time killer.
With great power comes great responsibility. Law enforcement officers undoubtedly possess great power, great capacity for good. But that necessarily equals great responsibility in the way that those powers are used. They have a right to kill a person if necessary. But they don't have a right to kill anybody without absolute necessity.
According to the prosecution, Raja may not have killed Jones out of sentimentality or rage, but rather out of a simple lack of concern. What else could this careless killer possibly done?
And he's going to explain to you, the judge will tell you what culpable negligence means. He's going to say it means a course of conduct showing a reckless disregard for human life or the safety of other persons exposed to its dangerous effects of conscious indifference to the consequences. I couldn't have thought up better words to explain exactly what he did.
However, the possibility that Raja may have plotted this from the beginning raises even more serious questions.
He was reckless from the start. He created the situation. The evidence is going to show you that he could have only expected one result. The death of Corey Jones. And that's manslaughter. It doesn't matter if we're bad. It doesn't matter if you're hopeless. It's manslaughter. But see, he doesn't get a free pass under the law for those last 3 shots. The last 3 shots that he waited 10 seconds to deliver. It took 1 second interval between each one. The law doesn't give him a free pass for those shots.
Raja has no points in his defense, no way to escape justice, and the walls are closing in on him fast.
You're going to hear medical examiner come up here, forensic pathologist, and explain to you all the injuries that Corey Jones sustained. He was shot in the left forearm, fractured the bone in his forearm to the point where it compounded. It came out of his skin. He was shot in the back of the arm, the back of this arm, on the right side of the upper arm, and it went through right at him. He was shot in the right side of his chest, and that bullet ripped through his body, destroyed his aorta, and lodged into his left shoulder.
The prosecution attacked Raja one last time, suggesting that while he may have been a criminal, he was not a clever one.
I'm confident that you're going to agree on the one verdict for which all the evidence will support. And that's the verdict finding him guilty as charged of being a reckless killer and for trying to murder Corey Jones. I'm going to ask you to hold him responsible for how he misused that power.
The worst aspect is that Raja showed no remorse and even attempted to justify his behavior with his family. But the judge, thankfully, did not see it that way.
Newman Khan Raja, defendant, verdict. We, the jury, find as follows. As to count one, we find a defendant guilty of manslaughter while armed with a firearm as charged in the information. As to count two, we find a defendant guilty of attempted first-degree murder as charged in the information. If you find a defendant guilty of attempted first-degree murder, you must next answer the following questions. Did the state prove beyond a reasonable doubt that the defendant actually possessed a firearm? Yes. Did the state prove beyond a reasonable doubt that the defendant actually discharged a firearm? Yes. Did the state prove beyond a reasonable doubt that the defendant in discharging the firearm actually caused great bodily harm or death to Corey L. Jones? Yes.
However, this case ended well because Raja had to face the consequences of his actions. Circuit Judge Joseph Marks could have given Raja a life sentence. Marks imposed a 25-year sentence on both convictions to be served concurrently. Up next, we have two other corrupt cops whose carelessness led to something very unfortunate, to say the least. On October 8, 2020, the Stockton Police Department received two 911 calls from a local AM/PM on Trinity Parkway, one from an employee and one from a customer, Shane Sutherland. The officers arrived at the scene, but the negligence on display ultimately caused something absolutely devastating and unfixable.
911, what's the emergency?
Can I get a taxi cab to the AM/PM?
This is 911, not a taxi cab.
I know.
Yeah, we don't order taxi cabs on 911.
Oh, well, yeah, that's,
You could try 411.
oh, no, that needs to come to, that needs to come to AM/PM.
What does?
What I call?
911?
Yeah.
What's your emergency?
Someone's trying to fucking rob me over here.
Who is?
Somebody in the store?
Are you an employee there?
Yeah.
What is your name?
Oh, no, I'm not an employee, I'm just a customer.
What is your name?
This was the first 911 call the police received. It suddenly and mysteriously ended.
The address of your emergency?
Yes, emergency.
You need police, medical, or fire?
Police as soon as possible, because the guy is trying to threaten us and just hold a bottle of wine and just he's going to throw it on us.
Okay, what's your name?
Calling. My name is. I just did call and nobody's
Yeah.
here, so.
Okay, we have an officer on the way, so I'll update them. You
Yeah,
said he's threatening to throw a wine bottle at you?
Yeah, he's grabbing a wine bottle right now, and he just took a bottle from the top, and he was trying to threaten us. And
Okay.
he's standing right by the register, so no customer could get to the register even.
Okay, I'll go ahead and update the call. Thank you.
Yeah, please.
Bye-bye.
There was no time to waste. This guy could have seriously taken someone's life if the officers didn't act fast.
You paying for it?
The officers then took the man outside to understand what had happened in a safe environment, so they could assess the situation to the best of their abilities.
Sit down, on your butt.
I was trying to buy a bottle of wine.
You were?
Yeah.
So how come he's telling us that you're threatening him with it?
I don't.
It's on camera.
Yeah,
All I got to do is go
I
look.
said I didn't threaten anybody with it.
You didn't hold it up like this?
No.
Okay. Do you have money to buy wine?
Yes.
You do?
Yes.
Okay, so why are you calling 911?
I didn't.
No?
No. I was just trying to call a cab company.
Why?
Well, because I needed to get a cab to
Okay,
my hotel.
but you called 911 and the dispatcher told you that.
No, I think it was already done.
And then you said and you said that somebody was robbing you.
No, that wasn't me.
No, that was you.
I don't recall, sir.
He was saying it was not him, but the officer kept putting words in his mouth. Someone should tell him that this isn't how a cordial conversation should go.
What's your name?
Shane Sutherland.
Let me see your ID.
Yep.
Don't get up. Just get it out of your pocket. You on probation or parole?
I'm on informal probation.
For what?
Just some old stuff from a long time ago.
What is that? What old stuff?
Nothing violent.
What is it?
Christ.
Spit it
I can't
out.
remember, sir. Honestly, I can't
Really?
remember.
You don't know what you were arrested for?
No, I
mean,
can't.
the drugs probably have something to do with it.
Yeah.
I'll run
Yeah.
with that.
How can the cop just assume role in his past arrest without any evidence to suggest so? The ignorance on display is appalling, to say the least.
I really haven't.
Well, no. There's either I do or I don't. Not I really haven't. You're high out of your mind right now.
This is
Cocaine?
Yeah.
Okay. When's the last time you used cocaine?
earlier this morning.
Okay.
Earlier today.
So is that why you're acting out the way you do? Sit down. Sit
Oh,
down.
sorry.
You may think the cops haven't done anything wrong yet, but your perspective is about to twist the other way absolutely.
At the Motel 6.
By himself?
I guess.
Yeah, I got ID.
Who do you live with at Motel 6?
Just by myself.
Yeah?
God.
Yeah.
Wait, which Motel 6? There's two of them.
The Motel 6 in Tracy.
Oh, and Tracy.
Yeah, by Panera Bread. Fuck you, dude. I'm sorry. I'm sorry. I'm sorry. Yes, sir. Yes, sir. Yes, sir. Yes, sir. Yes, sir. Yes,
Relax.
Yes, sir. Yes, sir. Yes, sir. Yes, sir. I'm relaxed.
Hey, relax.
I'm relaxed, sir.
Stop it.
Okay.
Don't
Hey,
Yes,
fight.
Sir. Yes, sir.
Knock
Yes,
it
sir.
off.
Yes, sir.
Knock it off.
Yes, sir. Yes, sir.
Dude, quit fighting.
I
You understand?
Yes, yes, sir. I got it. I understand. I won't move. I won't move at all.
The officer's telling him to quit fighting when he's so badly hurt that he's unable to resist.
I'm free.
You're not going to. Stop fighting.
Yes, sir. Yes, sir. I'm dead funny. Ah!
Relax.
Yes, sir.
You're.
Please let me breathe. Oh!
Knock it off.
Stop.
I promise, sir.
Relax.
I won't be breathing.
Relax.
I promise.
Hey, calm down.
Oh, I can't breathe. No.
Relax.
Ah!
We're not. Relax.
Ah! No!
Can you go to
No!
Go to.
Help!
These officers put the man through a ringer and expect him to calm down. As if this wasn't enough, their tyrannical actions only get worse from here. And their ignorance of Shane's cries for help resulted in something tragic.
Why?
Shane. 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 Relax. Relax. Hey, he's turning colors here. Relax. Relax. Got it? Relax.
These corrupt cops received no leverage. However, for this next cop, the courtroom turned into his personal graveyard.
Here, no, this is not a sentencing hearing. It is not a resentencing hearing. The sentence has already been imposed by Judge Nadel on December 5th, 2014. My job is solely to follow the law, abide by the rule of law, and execute the imposed sentence. But before we get to that, there are two things. First of all, I have in my hand a letter, which I've not shared with counsel because obviously everything needs to be on the record. It was hand-delivered to me moments ago from the Hamilton County Prosecutor, Joe Dieters. I will read it for the record.
The judge had already made it crystal clear. He wasn't there to hand down a verdict. His job was simple: carry out the sentence that had already been imposed on Tracy Hunter. There was no room for doubt, no chance for reprieve.
Dear Honorable Patrick Dinkelacker, you and I have known each other professionally and personally for almost 40 years. Today you are going to impose the sentence Judge Norbert Nadel gave former Judge Tracy Hunter after she was indicted by a grand jury, convicted by a petit jury, and upheld by every court in Ohio. It was also reviewed by the Federal District Court and the Sixth Circuit Court of Appeals and upheld. She has not once shown remorse. She has been incredibly disrespectful to you and to the justice system. She has in the face the fact that my office removed itself in any way from her prosecution, blamed us for her plight. That being said, I believe she has some type of mental condition that has created this scenario. Although we are not the prosecutors in this particular case, I ask as a friend of the court to consider an evaluation of her prior to imposing Judge Nadel's sentence. I have nothing but the greatest respect for you as a judge and, more importantly, as a person. I know in my heart that you will do what you believe is just. I've known you too long to believe otherwise. But she has basically lost everything professionally. A review of her stability to serve jail time hurts no one and may in some way aid in your decision to impose the sentence signed by Joseph T. Dieters. Any comment on that, Mr. Crosswell, first of all, sir?
Your Honor, I would endorse those comments.
The prosecutor had no objection to Tracy Hunter pleading insanity and even emphasized the importance of her undergoing an evaluation. But in a surprising twist, Tracy's own stance on the matter took an entirely different direction, leaving everyone in the courtroom stunned.
Okay. All right, thank you, sir. Mr. Singleton? I'm sorry.
I can't believe that Jody was asked for her to be done. In the letter, there's reference to her not showing remorse. Here's why there's not remorse.
Well, first of all, Mr. Singleton, with all due respect, you can. I'll certainly give you a chance to say anything you'd like. I'm just talking about whether or not you believe this is something appropriate for me to do.
No,
okay.
Absolutely not.
I appreciate that.
Absolutely not. And if I could just say more, I'd like to. The reason I say absolutely not is, first of all, both Jennifer Branch and I have worked very closely with Judge Hunter. There is no issue whatsoever, not in the slightest, about her not being confident or understanding what's going on. Absolutely what the courts have said about it, but under the plain language of the statute, she is not guilty of securing the authorization of an employment period. And we plan to file a motion to dismiss. I would ask the court not to impose sentence today. There's a chance to do that. I would ask alternatively that the court not impose or execute the sentence today, because we are still on appeal of the habeas denial in federal court. And we would ask the court to stay execution of sentence until we finally resolve that issue. And let me just say a word about what she's gone through, because I think that gets lost sight of. Every day for the past 5 years almost, Judge Hunter has gotten up each morning not knowing whether that was going to be the day that she was not going to jail. I know by talking with her, by observing her, the impact that has had on her life.
Tracy's lawyer presented a series of articulate arguments in her defense, painting a compelling picture of injustice. Yet glaringly absent was any acknowledgement of the fact that every court that reviewed the case had unanimously determined she received a fair trial. It was a bold move, but would it hold up?
We believe it would be profoundly unjust and unfair, and a waste of taxpayer dollars to incarcerate her for 1 minute in the jail. We believe it would be profoundly unfair and unjust and a waste of taxpayer resources to put her on probation. What we ask the court to do is just end this today. But not incarcerate her, particularly given that we're going to file this motion to dismiss. We would ask the court for the continuance for us to be able to address that.
Oswald?
No, if I might, simply in response to the letter, Mr. Singleton indicated that he did not believe, or that he did believe that Ms. Hunter was competent to stand trial. I would agree with that. I don't believe that Mr. Dieters' letter was speaking to the issue of whether she was competent to stand trial or whether she was legally insane for the purpose of the trial. No one has raised that issue. It's not even been considered. I believe the letter that Mr. Peters has written, and that I, when you asked, endorsed, was a letter which asked to have an evaluation for the purpose of sentencing.
I appreciate that. And since defense counsel has indicated that they do not wish for me to proceed in that manner, I will certainly not do that. I do appreciate the concerns Mr. Dieter has extended, but that is something that we're not going to proceed with. The other thing I do need to do before we get to the other aspect of this case is, I thought about this for a long time, and on behalf of the justice system, preservation of the independence of the judiciary in the spirit of transparency and to comply with the dictates of Ohio Code of Judicial Conduct, I'm going to state the following. In no way, shape, or form.
The courtroom fell silent as the judge began reading aloud letters he claimed were sent directly to his home.
I want to point out for the last several weeks, I have received at my home, not here in the courthouse, at my home, 45 postcards from people, some of them signed, a few, some of them with return addresses, a few, but most of them anonymous. So when my wife got the mail, she looks at them, of course, she becomes concerned. I'm not going to read them all, obviously, but again, in complying with what I think is law, and so no other judge should go through what I've gone through with these Facebook postings by certain people and whatever, okay? I'm just going to put a couple of these on the record. 7 of them start off with, I am a registered voter, okay? What is that supposed to mean? Well, whatever. I'm a registered voter and I believe all charges should be dropped against Judge Tracy Hunter. I'm a registered voter who stand and support Judge Tracy Hunter. Drop all charges against Ms. Hunter and exonerate her now. Dear Judge Dinklager, please exonerate Judge Hunter of the charge she was falsely accused of. I'm a registered voter in Hamilton County. Judge Dinklager, exonerate Judge Hunter now. Drop all charges, restore her good name. I am a taxpayer and a registered voter. I'm a registered voter. Please let Tracy Hunter. She is innocent of all charges. As a concerned citizen and a registered voter, I urge you to exonerate Judge Tracy Hunter now. I'm a registered voter in Ohio, and I'm asking that you release Tracy Hunter of all charges. Having said that, I now refer to Rule 2.4 of the Ohio Code of Judicial Conduct, external influences on judicial conduct. A judge shall not be swayed by public clamor or fear of criticism. B, a judge shall not permit family, social, political, financial, or other interests or relationships to influences the judge's conduct or judgment. And C, a judge shall not convey or permit others to convey the impression that any person or organization is in the position to influence the judge. Having said that, I say to the organizer that did that, and obviously it's organized because these will be made public record. Every one of them has a label addressed to Judge Dinklager at my house. The stamps are all the same. So somebody organized that for whatever reason.
The lawyer asked for permission to speak, but the judge harshly declined, showing that he has no tolerance for any cunning antics that the defense may have chosen to pull.
But I don't think there are too many people in this community, on both sides of the aisle, in prosecutor offices, in defense lawyers' offices, people on the street, who believe that the sentence is right. Putting aside whether the conviction is right, which we contend it's not. So, I would ask you on behalf of Tracy Hunter to end this debate for her. She has had, as a result of this case, she's lost everything almost. There's something that's important that she hasn't held on to. But she's lost a lot. She lost her job as a judge, her law license, her ability to earn an income. But I don't think there are too many people in this community, on both sides of the aisle, in prosecutor offices, in defense lawyers' offices, people on the street who believe that the sentence is right. Putting aside whether the conviction is right, which we contend is not. So I would ask you on behalf of Tracy Hunter to end this debate for her. She has had, as a result of this case, she's lost everything almost. There's something that's important that she hasn't held on to. But she's lost a lot. She lost her job as a judge, her law license, her ability to earn an income.
Tracy's lawyer tried to invoke sympathy for her on behalf of the judge, but the prosecutor had a much different view of the events that had occurred and their repercussions.
That when Mr. Peters wrote the letter asking you to at least order a mental health evaluation, and I endorsed it. I said, well, that's fine with me. It's somewhat ironic that the person who said that they did not want the mental health evaluation was Tracy Hunter herself. Now, anyone who has been in the system or around the system understands that when Mr. Peters presumably is asking for a mental health evaluation, it arguably would be to see if there's some type of way for Tracy Hunter to avoid this and simply as a mental health issue. Yet she is the one who stands here before you today and says that she doesn't want that either. In other words, what she wants is to control the facts. What she wants to do is write the law, and what she wants to do is play by her own set of rules right up until today, right up until this very moment.
Regardless of whether this federal court ultimately agrees with Judge Hunter on the merits of her claims, this case presents an opportunity for the federal court to restore lost confidence in the justice system by giving Judge Hunter a fair opportunity to be heard in federal court, a venue that the community trusts as being above local politics before she is put in jail. Judge Black then says this federal court now discharges that duty with this decision. He goes on further on page 22 to say, the last paragraph, nevertheless, in summary as to this objection, the evidence at trial that Hunter had delivered to her brother documents to which he was not entitled for the purpose of protecting his employment as a juvenile correction officer at the Hamilton County Youth Center, as well as the testimony regarding Hunter's additional conduct intervening on her brother's behalf, and I quote, strongly supports the jury's verdict that Hunter was guilty of having an unlawful interest in a public contract. I've read it once. I'm not going to go through it again. Just to note, all the state courts have looked at this. Every one of them have said that Ms. Hunter received a fair trial. We went to the federal court. You can shake your head if you'd like. The federal courts also said she received a fair trial all the way up to the Sixth Circuit Court of Appeals. The only thing left is the Supreme Court, and I doubt that they're going to take it in. They all did their duty, and now it's my turn. To follow my oath, uphold the rule of law. In this case, the law certainly permits it, and I believe justice, I'm sorry.
One second.
As the judge slowly shot down all points in favor of Tracy using evidence from the case, he neared the final decision.
What are we doing here, Mr. Singleton?
Oh, sorry, Judge.
I gave her an opportunity to speak, and that was turned down. It's not being offered now. Please have a seat. Ma'am, please have a seat. Thank you, ma'am. Just the record should reflect again, you were offered an opportunity to speak, and you turned that down. Please, everybody's been great. I appreciate that. It is a court of law. Thank you for that. And, as you all heard, she was offered an opportunity and turned that down. So, Ms. Hunter orders the execution of the sentence imposed on December 5th, 2014 by Judge Nadel. That is as follows. 1 year community control. That's non-reporting. Since you will be on community control, I will advise you, as I'm required to by law, that if you violate any of the conditions of the community control, come back in front of me. I will sentence you to 18 months, the Ohio Department of Corrections. It is a felony of the 4th degree. The conditions of the community control are real simple. as indicated in the judgment entry by Judge Nadel. Number one, you pay the cost of these proceedings. Number two, you are to do not violate any laws. Number three, you are to do 6 months in the Hamilton County Justice Center, credit 1 day. Mr. or Ms. Deputy can take her away.
After several hearings, Tracy finally decided to serve out her sentence and not appeal. She was accused of giving confidential records to her brother, a juvenile court employee who was in the process of being fired. Hunter was sentenced to 6 months in jail minus 1 day. The case dragged on for years, exhausting the appeals process, and finally ended with Hunter being taken into custody in 2019 in a Hamilton County courtroom, despite her physical objections. She served 75 days in the county jail. While this former judge was convicted and sentenced for her illegal actions, this officer's blatant disregard for human safety in light of his hideous actions is even more disgusting.
The next case is slamming the face into a pine tree. Do you have to have a pine tree case?
On June 22, 2016, Officer Robert Massie intervened in an argument between Jacob Tellis and Basilia Mina, which unfortunately took a brutal turn. The events led to a hearing against Massie, which is depicted in the video.
Please the court, good morning, Your Honors. Dennis McLaughlin for the City Attorney, representing Officer Massie, Tucson City Attorney. I would like to recognize the skillful briefing of my colleagues, Viola Romero on the opening brief and Michelle Saavedra on the reply brief. With Your Honor's discretion and consistent with our colloquy, I would like to reserve 2 minutes for rebuttal.
Okay, keep your eye on the clock. It counts
now. I will do
down.
that.
Yeah.
Qualified immunity case. Your Honors are well aware of the standard, two-pronged standard. There needs to have been a constitutional violation, and it needs to be clearly established in law at the time that the events occurred. This case is 2.5 years old, and the plaintiffs have never brought any case forward that actually makes clear that that this would have been a violation for what the officer did.
Can you tell me what level of specificity is required to meet that prong? Does it have to be a case that says, hypothetically, slamming a woman's face into a palm tree is a violation of the Constitution, but if the next case is slamming the face into a pine tree, do you have to have a pine tree case?
The judge rightly called out the lawyer, as he refused to undermine the severity of the assault the officer had inflicted on the woman by talking about trivial aspects of the case.
What is the level of specificity?
Your Honor, what I understand the level of specificity to be is you don't have to have clear, all that the Supreme Court has said is you don't have to have clear precedent that's exactly on point. But it has to be reasonably clear, I would say more than reasonably clear, to a reasonable officer that what he or she is doing is wrong. And we do not have that in this case. Oh, I understand your concern. We do not have that in this case. We have a situation where a woman is in the median, she's intoxicated, she's antagonistic, she's uncooperative, she won't move away from the person she's with, which means that, and she won't give identification. So the officers can't investigate anything of what they are suspecting. Moreover,
what were they suspecting? It's unclear to me.
Either possibly domestic violence, Your Honor, or underage drinking. And
how old was she? I didn't even.
If you look at the pictures, which I think are ER 39,
the ones with the big gashes on her head.
Yes. Yeah. She's 22. I believe she's 22 at the time. But she's one of those lucky people that it's hard to tell how old she is, whether she's younger or older.
But it sounds as though in this instance, under your argument, she's not lucky at all, because you're using that against her.
Well, that's true, Your Honor, but that's right. But the point is the officers don't know when they're investigating whether she's underage, and that's one of the things they're looking for. I do want to emphasize, Your Honor.
I don't think there's any serious dispute that they had some ground for the arrest. I mean, just the refusal, or I don't think that's part of the fight.
Right, or detention. The court actually found that there was reasonable grounds for the detention, and there's been no appeal.
Right.
So now, what does the officer do? It's a median of one of Tucson's busiest streets. There's traffic going by both ways. He's got to think about her. He's got to think about the safety of the officers. He's got to think about the safety of the public. So what does he do? Well, one of the reasonable things that he can do is, and probably we argue the best thing he can do, is take physical control of her and get her off that median.
Of course. But according to her evidence,
the lawyer had made some important points about controlling the medium, but what the judge said next completely shut down his argument.
One of the things he does is shove her face into the bark of the palm tree. That's not getting her under control and getting her off the median. That's something distinct. So her evidence is he deliberately pushed me into the palm tree and caused me injury. So that's what you've got to contend with.
Right. So obviously, Your Honor, we don't agree with that, but you're dealing with what she's alleging.
Well, no, it's her statement. It's her evidence.
Right.
Handcuffing someone is uncomfortable. Detaining someone is uncomfortable. But when it reaches the level where you need medical attention, that is, to me, where that line is, where there's at least a body of law that makes it clearly established that this, at least arguably, is excessive force. Now, you may well win before a jury. I mean, I don't know all the details of how much she was resisting and things like that, but it seems to me that when there's medical attention required, that's where the line is. Disabuse me of my notion.
There was the only medical attention that was required here, Your Honor, was one visit where she got some, I believe, some topical ointments. There was nothing else that she did.
Oh yeah, but I mean, you've seen the pictures. I mean,
I would also point out, Your Honor, that under Luktel,
the judges claimed to have seen the pictures where the woman had clearly been injured and stated that as clear evidence to the contrary of what the lawyer claims.
May it please the court. Good morning. My name is Damian Gallagher, and I'm here for Ms. Mina, the appellee. I'd like to start at the point that Judge Malloy noted that this case is coming down to whether it's a pine tree or a palm tree, and that simply is not the law within the Supreme Court nor this circuit, as it was clearly established in 2016, as it is today, that an officer may not employ non-trivial force against an individual who is not resisting arrest nor passively resisting arrest.
So how do we determine whether it's non-trivial force? Is it, I mean, can we look to the injuries? Is that determinative or is it not determinative?
Your Honor, in evaluating whether or not the force is trivial or non-trivial, it of course is a reasonableness inquiry under the Fourth Amendment, but typically in the excessive force context, it's evaluating whether or not that force was necessary and the degree of that force was necessary in effectuating that arrest. And here it was non-trivial because Officer Massie had Ms. Mina within his custody when he was handcuffing her, and once he pinched his hands in the handcuffing, that's when he retaliated against her by thrusting or shoving or whichever verb this court chooses to adopt, and threw her into a tree where, as this court has noted, she was bleeding and had scrapes on her face and shoulders.
Well, how do you establish the level of specificity? And I refer to my colleague's concurrence in the Green case talking about the U.S. Supreme Court articulating that it can't be at a level of generality, but it doesn't have to be a case directly on point. How do you balance those things?
Your Honor, this court in Ostalinsky, as well as the Supreme Court in Anderson, has noted that a law is clearly established when a reasonable officer would understand the contours of the alleged misconduct and would know that the action would violate those contours. And here, we have defined this at a level of specificity, that an officer may not employ non-trivial force against an individual who is not passively resisting arrest. This court has made that clear in Graveland-Blondin, and if I may, Your Honor, this court has stated, though these cases do not concern tasers, they need not, citing Diorle, it does not matter, and that no case of this court directly addresses the use of that particular weapon. We have held that an officer is not entitled to qualified immunity on the grounds that the law is not clearly established every time a novel method is used to inflict injury. And in Graveland-Blondin and Meredith, whether it's a taser or whether it's handcuffing, this court has focused on the degree and necessity of that force, not the particular weapon. And additionally, this court has focused that in Mendoza that the very act in question does not have to be previously established. Again, relying on the legal principles and the holdings from this court, not the particular weapon.
No, the excessive force cases we're accustomed to seeing, they're almost all gunshots.
Despite the lawyer's reasoning, the judges were still skeptical and continued to ask him questions regarding the case.
I've never seen a case, an excessive force case, where the injuries were so minor. Are there any other cases of which you're aware where the excessive force resulted in injuries of this sort? I don't want to put them aside in the sense that there's no injury. There was clearly injury. We see the photographs and so on. But are there other excessive force cases in which the injuries were of this sort?
Yes, Your Honor. And in Meredith, that was a tight handcuffing case, and there the injuries were scratches on one's hand, on the wrist, I believe, and it's almost similar to the ones in the case at bar. Although it does seem that the injuries that Ms. Mina suffered were, rather bloody and uncomfortable. But it's also worth noting to stress that her injuries are not only physical, but they're also emotional and psychological damage as a result of this incident. He never asked her for her name. He only asked for her ID, and therefore not even violating the law. And so to the extent that Officer Massie used force that was not necessary, this force was non-trivial and violated Ms. Mina's constitutional right. And because this was clearly established in 2016, as it is today, we respectfully ask this court to affirm if the court does not have any further questions.
Okay, thank you very much. I do have one further question, and this is for the courtroom. You're a law student?
That's correct, Your Honor.
And where are you a law student?
I'm a third-year student at William & Mary Law School.
Okay, thank you very much. And we would like to compliment you on the quality of your presentation. I'll compliment you too, but you do this for a living.
Yeah.
So,
Thank you, Your Honor.
Thank you.
The judges, clearly impressed by the young law student's showcase of ability, complimented him in regards to it.
En banc case called Matos v. Agarano that this court has decided, where domestic violence is the volatility of those situations is recognized and the great danger of them is recognized. So this is not just she didn't show ID. There were serious matters to be looked at. I'd also mention just Parker, that Parker only said in 2018 that a shove would not be, there was nothing to say it would be a constitutional violation. Clearly in 2016, that's also the case. So we're always back to this second prong, and that's where we think we win.
The officer's hideous assault of Mina can be observed in its full extent in her testimony. According to Mina's testimony, Officer Massie pushed her face into the bark of a nearby palm tree, causing injury. Mina filed a complaint alleging civil rights violations, including illegal seizure, false arrest, and excessive force. Massie's attorney argued for qualified immunity, contending that his actions did not violate the Constitution. However, the district court denied qualified immunity on the excessive force claim. Like in this case, this next officer also failed to get away with his wrongdoings as his case came before a righteous and no-nonsense judge.
The only way I can make sense of the sentencing, and I also want everyone to understand where I'm coming from with regards to this, especially if there's going to be any appellate review of this sentence.
Michael Dotro, a former Edison police officer, was charged with firebombing his supervisor's home and other retaliations he had orchestrated against those who wronged him.
This particular case,
is because Mr. Dotro, through his conduct and his admissions, spanning 1998 to this year, represents the worst that we can possibly expect from someone in our society. Yes, he's caused very specific damage to Captain Endurple and his family, to Ms. Zog, to Ms. Dotro, to his own parents, to his families, to his brothers. But what he's really done.
Dotro is sentenced to 20 years in prison for his misconduct. Before his sentencing, the judge gives a speech on how and why they decided to give Dotro such a sentence, even though he's also a law enforcement officer. He speaks about the law and why he wants victims to have faith in the law once more.
To spend the next third of his life in prison is allow people a basis to say that our system of justice has no integrity. How could it when we've allowed this particular individual like him here in Middlesex County, here in Edison, to do the things that he's done, similar to what we see on the news every day from other parts of the country. Because of what this individual has done, because of him and people like him, victims are afraid to come forward to be part of the criminal justice system and get the relief that they're entitled to from being victimized, because they have no faith in it, because they don't know who to trust. Even more importantly, we have other individuals every day who put on a badge which represents honor, service, and integrity. And without question, go out there every day, leave their family behind to protect an entire community with hopes that they can make it through the day, through the end of their shift, so that they can go back home to their family and lead a normal human being life, because the life of a police officer is not a normal human being life.
This instance showed us that no matter how corrupt someone is, the law always catches up. And this is the same case with this next cop, who had absolutely no idea what hit him.
I didn't even touch you. Your leg.
Corruption in the ranks of those sworn to protect us is a betrayal like no other. But what happens when justice strikes back right in the heart of the courtroom? This corrupt cop got instantly attacked in the courtroom and didn't even know what hit him. On February 4th, 2019, Officer Andrew Mamone stopped a car that was allegedly being driven in a suspicious manner. During the traffic stop, he discovered that two men were in possession of marijuana. Both men were asked to exit the car. The driver gave his real name, Tarek Green, but the passenger gave the false name of Cary Grant. His real name was Daquan Grant. Unfortunately, the officer and Mr. Grant had a very violent altercation that led to a thorough internal investigation.
For right to a representative of your choice, and your representative here today is
Sean Dunlap.
Today's date is May 28, 2019, and the time is now 10:34 hours. Officer Mamone, there are certain things you should be aware of prior to being asked any questions. This interview is an official investigation assigned to Internal Affairs by the Chief of Police. This investigation concerns administrative matters only. Anything you say in this interview cannot be used as evidence in any criminal proceeding against you, except pursuant to Chapter 837 Florida statutes regarding perjury. Officer Mamone, you are a principal in this investigation. Are you now on duty?
Yes.
The inquiring party in this inquiry is Sergeant Wesley Whited.
The interrogator just stated standard rules and regulations.
The nature of this investigation and this inquiry concern alleged violations of RM 800-2, arrest, subsection C, treatment of prisoners. This inquiry also relates to the circumstances surrounding all incidents which took place on February 4, 2019. For a point of record, on the INOI, the date says February 2nd, 2019, but the date is actually February 4th, 2019. I order you not to discuss any facet of this investigation with anyone except your legal representative, union representative, and internal affairs. A violation of this order will be considered insubordination, which may result in discipline up to and including termination. This order remains in effect until relieved by competent authority or the investigation becomes public record.
The interrogator warned the officer that he'd be charged for perjury if he lied and was caught.
Additionally, Chapter 112 Florida statute prohibits your legal counsel or representative from disclosing the contents of the internal affairs complaint and investigative findings until the investigation becomes public record. A law enforcement officer or witness who knowingly provides or makes a false statement during an internal or administrative investigation may subject that officer to prosecution for perjury. Department regulations require you to answer my questions and to be completely truthful. I now order you to answer the following questions. Please raise your right hand. Do you swear or affirm the statement you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
He told him that information was given to him and nothing had been disclosed, and made him sign a document which basically meant that he was provided with every material related to the car.
You have been provided for your review the complaint, all witness statements, including all other existing subject officer statements, and all other existing evidence, including but not limited to incident reports and any audio or video recordings relating to the incident under investigation. No information of material fact relevant to this investigation has been intentionally kept from your attention and review. Now that you have had an opportunity to read and review the aforementioned case file, do you have any additional identifiable witnesses before the beginning of this interview?
No, ma'am.
Could you please sign and date the attachments page indicating that you were able to review the contents inside and that this stuff matches up with what's in here? Outside of your interview, Jordan has to be interviewed again.
The real interview is finally about to begin.
For the record, this is an official investigation and not a formality. Officer Mamone and Representative Dunlap, do you have any questions or concerns prior to the start of this interview process regarding this investigation?
I do not.
No.
Do you have any questions or concerns regarding this investigation as it relates to the FOP contract and Florida State Statute 112.532, the Police Officer's Bill of Rights?
I do not.
We reserve any of those concerns for the grievance or arbitration process.
Understand you're reserving your right to raise such issues in the grievance or arbitration process. As of today, would you like to continue with the interview?
Yes.
Please state and spell your first and last name for the record.
Andrew, A-N-D-R-E-W, Mamone, M-A-M-O-N-E.
And how long have you been with us at OPD?
Over 3 years.
And did you have law enforcement prior to that?
Yes, ma'am. Over 2 years at the City of Sanford.
Any more?
Nope.
Okay. Where are you currently assigned?
Vehicles for hire.
Where were you assigned when the incident occurred on February 4th, 2019?
West Patrol Division.
Mamone started off very confident. Without hesitation, he was able to answer questions. He would have known what was coming, so it wouldn't have been hard for him to prepare.
And how long were you in that spot?
Up to the month of March of this year.
March.
From the date of hire.
Okay, so you transferred somewhere else in March?
Yeah, I transferred to East Patrol Division, Kilo Alpha Mids.
Okay. We're here reference IR 1933. This INOI is in reference to a possible violation of RM 800-2 arrest, subsection C, treatment of prisoners. Did you have an opportunity to review the body camera footage related to this incident?
Yes, ma'am.
Did you review it?
Yes, ma'am.
Okay. The other two officers in this video, these are officers Madison and Seitz, is that correct?
Correct.
Were you riding solo or two-man?
Two-man capacity.
And were you the driver or the passenger?
Passenger.
The interviewee then confirmed some details of how the incident happened.
So originally you all conducted a traffic stop, is that correct?
Correct.
Okay, and then at some point you got them both out of the car and you were trying to identify who the passenger in the car was, correct?
Correct. We established probable cause for research.
Okay. While you all were standing, I think you were still inside the vehicle, and officers Madison and Seitz were standing up, and you were eventually able to get a positive identification on the passenger, correct?
Correct.
At that time, he took off running away from you guys, correct?
Correct.
Tell me what happened after that.
She then asked what happened after the man ran away.
The Mr. Grant, the suspect, the passenger in the car who I was attempting to identify, was looking back. Based off the false identification he provided, I used that as clues through the mugshots program to try and find his real identity. Upon finding his real identity, I guess he picked up on my verbal and nonverbal cues that I have positively identified him. Once I stepped out of the car, he began to run at a full sprint. I guess it would be like northwest from us, towards the entrance of Timberleaf and Greenbelt, which is Timberleaf Apartments.
Okay, and then what happened?
Due to the fact he was providing active physical resistance, I deployed my electronic control device after he fell, popped up, and then attempted to flee again. It had a positive effect of him going to the ground. He didn't fully lock up, but he did go to the ground.
Mamone then explained the line of events before he told Mr. Grant adjusted his handcuffs.
Which then Officer Madison and I were able to use hands-on techniques to keep him from getting up and trying to flee again.
Okay. So you two get him under control, and you eventually stand him up, and you all walk back towards where Officer Sykes is, correct?
Correct. When he goes to the ground, he flips his handcuffs. His handcuffs are on the front.
Yeah.
It's problematic, of course. And then myself and Officer Madison walk him back to the patrol vehicles and the original scene of the traffic stop.
Okay. What happened when you get back to the original site of the traffic stop?
Mr. Grant is placed on the ground in a kneeling position, and he is told to put his handcuffs back behind his back.
The interviewee then questioned what Mamone was taught. Mamone is unnecessarily specific about his training. It seems he doesn't know what the word intuition means.
How do you normally handcuff a person if they haven't been handcuffed?
If they are not handcuffed, you handcuff them behind the back.
Okay, what if they say the handcuffs are twisted or hurting them? How do you unhandcuff them to readjust it?
I have not been trained on handcuffing a suspect based on his complaint of pain.
Have you ever had to adjust a handcuff on a person?
Yes.
How?
When they're behind his back.
How?
By placing my handcuff key in the handcuff and adjusting them behind his back.
Okay. So he's on the ground and you tell him to put his hands back and behind him, and what does he say?
He fails to comply with the order.
What does he say?
You'd have to play the camera for me to repeat verbatim what he said.
He kept mentioning his training. Training isn't supposed to be this specific. A human brain exists. This is just poor judgment of a situation. He fails to realize that because he's that dumb.
And even then, you just have to listen. I don't know from memory.
At the time, the suspect had said that the cuffs caused him pain, which shouldn't be difficult for Mamone to remember. He suddenly had memory problems when it came to recalling this.
Get these handcuffs back behind him. Where do you think you're gonna go? Y'all gonna run us with handcuffs on. Now you're gonna stop. Now you're gonna drop down to your knees. Now you're gonna fix your handcuffs, gonna put them back behind your back. No, it's okay, let them go. Put them back. Put them behind your back. Go on. You're the one who got them in front, you told me. Put them on your knees, put them on your back. If you do anything other than what I say, you get sprayed in the face.
If you just say if I move.
Put them behind your back.
You just say if I move, you're gonna spray me.
You're gonna put those behind your back.
He might have some kind of mental. What's wrong? Why can't spray him?
Oh no, he just likes them. Go on, put those.
How did you get him out? How did you get him out? He's not telling me not to move.
You shut your mouth. You shut your mouth.
Upon hearing the video, Mamone said that he wasn't actually trying like he said in the video. This is a very stupid thing to say. He can't just say that and lie flat in front of him.
Put those under your knees, slip them under your knees and around your back. If you gotta go to your side, go to your side.
You just
do what you gotta do to put your handcuffs behind your back. How's that?
Look, I'm finna lay you down, and you gonna do what you gotta do.
There you go. Now put your legs through the cuffs.
That's what I'm trying to. Like, it feel like I cannot move. I swole. You look me in my. I swole.
Put them behind your back.
Oh my God.
Put them behind your back.
Go on.
Look at me. I tried to, bro.
You're not even trying. Not even trying.
So he says he's trying to, right?
That's what he says. He apparently made no physical attempt, but he says he tried to.
Okay, but he said he tried. That's what he said.
That's what he said. No.
Not even trying.
So when he says he's not even trying, is he just laying flat, or what is he doing at that point? I can't see on your.
Mamone kept insisting to the interviewee that Mr. Grant was not trying, but the interviewee's not dumb enough to believe his lies.
You do see a little when it pans back and forth. When he originally laid on his slide,
I can't see his full body on your body camera right during none of this. Like, I can't see his body. I see his foot.
Yeah, exactly. So you see his foot. I recall from him with his legs outstretched, not attempting to even bring his knees to his chest to flip the handcuffs.
Okay. And he says he can't.
Yeah, but he hasn't physically tried, and he says he can't. Correct.
Okay, well, there's some things that I know I can't do without having tried, but I understand what you're saying. You're saying you didn't try.
I'm about to unstuck you.
Correct.
You want to do it, you want me to do it for you?
Look at me. I tried to, bro.
You're not even trying. Not even trying.
I tried to.
Not even trying. You're stuck? I'm about to unstuck you. You want to do it, you want me to do it?
What does that mean? I'm about to unstuck you.
I can't recall it because I can't see him.
She questioned what he meant by, "I'm about to unstuck you," and he suddenly can't recall what he meant. Ridiculous.
You said it. What does it mean?
I can't recall because I can't see. He said, I don't know what he means by I'm stuck, so therefore I don't recall what I meant by I can't unstuck you.
And why were you going to pepper spray him?
If he provided physical resistance, my use of force choice probably would have been pepper spray.
Pepper spray is definitely overkill for someone that's on the ground and handcuffed.
Shut your mouth. You shut your mouth. Put those under your knees, slip them under your knees and around your back. If you gotta go to your side, go to your side. You just do what you gotta do to put your handcuffs behind your back. How's that?
Look, I'm finna lay you down, and you gonna do what you gotta do.
There you go. Now put your legs through the cuffs.
Like, it feels like I cannot move. I swole. You let me in my... I swole. Like,
put them behind your back.
What is he saying there? I'm what? Swole?
Yeah, that's what he said.
Go on.
Look at me. I tried to, bro.
You're not even trying.
I swole. Like,
put them behind your back.
Oh my God, that's before.
What was the purpose of shaking the pepper spray?
I don't recall. Am I shaking pepper spray?
Yeah.
And he didn't recall again. Isn't that a surprise?
Go on.
Look at me. I tried to, bro.
You're not even trying. Not even trying.
I tried to.
Not even trying. You're stuck? I'm about to unstuck you. You want to do it, you want me to do it for you? You want to do it, you want me to do it for you? Okay, we'll do it for you.
What the?
I didn't even touch you.
What the?
Put your leg back around. Go on, put your leg back around.
I cannot, bro. Look.
Okay, he said, I cannot. And now you're forcefully pulling his leg through the handcuffs. Why are you pulling his leg through the handcuffs?
To get them repositioned to the rear.
He said that he couldn't and that he was yelling because it hurt.
We don't know if he's yelling because he's hurt.
The audacity of this man to say that Mr. Grant was yelling for no reason, that he wouldn't be in pain, considering what was being done to him.
I can yell right now. It doesn't mean I'm in physical pain.
He was yelling as you were pulling his leg through the handcuffs.
Correct, he was.
So that wouldn't indicate that it was hurting him?
Not necessarily, ma'am.
Why else would he be yelling?
For any various reasons. Draw a crowd. We see if you get attention to people in the apartment. That's a common thing that we see when we're out on patrol. People will scream even in the back of a patrol car just to get people to the scene.
He had obviously started being defensive, which is proof that even he knew he was doing the right thing and that he was using too much force.
No, you can't.
Bro, I tried.
You're not trying, you just did. I just saw you do it. Oh, that's all right.
He said, I'm trying, I can't, and you're still forcefully pulling his leg through. Why are you still pulling his leg through?
Same answer, to get his handcuffs repositioned to the rear.
But he's saying that he can't do it. Why are you pulling his hand through? If it's hurting him and he says he can't do it, it's not going to work.
We don't know if it's hurting him. And the same answer to put his hands behind his back.
We'll get it. We'll get it. Go on, stick your foot through. I see people do this every day. Come on. Come on. Stop. But you stop fighting me and just do it.
Look, bro, I'm going with you, bro.
No, you're not. No, you're not. Put your foot around. That was not hard. Now do the other one.
The video continued to play, and now he does the same torture with the guy's other leg.
Do the other one. Do the other one. Put the handcuffs back behind your back. Go on, do the other one. I'm not taking this cuff off. Your cuffs aren't going back. You already ran once. I ain't going to take them off. Put your other foot. I'll do the other one.
So you didn't want to reposition the handcuffs because you haven't been trained or because he already ran once?
I haven't been trained in repositioning a suspect who has fled from the scene, who has flipped his cuffs on the ground to reposition him in his back, ma'am.
Okay, so you didn't have control of the prisoner?
No, I never said we didn't have control. I said I've never
I'm
been
asking
trained.
you, did you have control of him?
I can't say we did.
It's not a trick question. Just
well, it is because it depends on your definition of control.
He continued to blame the training. He refused to take responsibility. Absolutely pathetic.
Was he free to go?
No, ma'am, he's detained.
Did you have physical control of him?
Like I said, that determines on your definition of control. If I put him in the back of my patrol car, would you say I have physical control? But I don't, even though he's detained in the back of the patrol car.
Is he free to leave?
No, he's detained, ma'am.
Okay. Is he under arrest in the back of the car?
Yes, at this point he's under arrest.
Okay. So what was stopping you from unhandcuffing him and putting the handcuffs behind his back?
I've never been trained to do that.
You've never been trained to unlock a pair of handcuffs?
Not from a person who has fled and lied about his name.
That has nothing to do with you unlocking a pair of handcuffs. Nothing. Have you been trained to unlock handcuffs?
To unlock handcuffs?
Yes.
Not when they're from his body.
Does this guy even hear himself? What nonsense is he saying? Unlocking handcuffs off of anyone just requires you to know how to unlock handcuffs.
Ever been trained to unlock handcuffs? That's all I'm asking you.
Not in the front of a person's body.
Can we take a break?
You sure can. 10:50 hours.
They definitely needed a break to talk because Mamone here is just making an utter fool out of himself. Furthermore, there was an argument in the hall in the break which should not have taken place. It begs the question about whether this is actually an investigation or a formality to fill paperwork.
We are back in the interview room at 10:54 hours.
Eventually, the silence was finally broken by the interviewee.
Attempted homicide in North Charleston, South Carolina.
Officer Dunlap.
Can we back the video all the way up to the beginning, please?
Looking for when they ran. It's around 28:13.
Where's 20?
We're gonna stay just like this.
Mamone's representative, after permission, looked for the part in the video where the suspect ran.
Yeah, that's because your face is in dirt. Sit down. Sit down or you're gonna get it again. Roll over. Hey, roll over now. Oh, that's all right. I'll use my hands now.
Did you hear him wince in pain when he pulled his hands up to the front?
No, sir.
That's it.
Do you want to clarify or add any statements made by you during this interview?
No, ma'am.
Is the testimony you provided true and correct?
He viewed the footage he was looking for. The interview was pretty much about to end.
Identifiable witnesses that may have evidence of material fact in this investigation?
None than the ones listed here on the sheet.
Okay.
After the break, the line of questioning was changed and the interviewee concluded the interview quite hastily. After the investigation by Internal Affairs concluded, it was determined that Officer Andrew Mamone had acted with unnecessary force. Officer Mamone was, as a result, suspended for 24 hours without pay. He grieved the suspension, but the grievance was rejected. If you enjoyed this video, make sure to leave a like and comment down below with your thoughts. And if you liked this video, you'll love this next one where these good cops humiliate the out of evil cops.
I'll give you one more chance here in a few minutes, and I'm not going to talk to you anymore. I'm telling you that.
Well, what happened?
You know what happened. I'm not going to sit here and play games with you. I'm not. I know. You know.